Hello and welcome to the Kenneth for Camel Law Office Legal Podcast, and we're looking at the cases that were discussed at the New Jersey State Bar Association seminar handling drug, DWI, and serious motor vehicle cases. And we're looking at cases 11 through 15. In case 11, let's say, can the judge automatically deny adjournments? Let's say when someone's already represented by a public defender, and obviously the answer is no. In State versus Cates, the New Jersey Supreme Court held that a defendant can be entitled to an adjournment to select their own counsel. The judgment of the appellate division was affirmed substantially for the reasons expressed by the appellate judge Oster. Deprivation of a defendant's right to counsel is found where here the trial court denies an adjournment without properly considering the relevant factors or abuses its discretion in doing so. And that's State versus Cates. Case 12. Can the police contact T-Mobile or your cell phone provider to determine where you may be at? Answer is no. Cell phones can be tracked without a warrant, and that's State versus Earls. There's a good quote: no one buys a cell phone for the purpose of sharing detailed information about their whereabouts to share with the police. Case 13. Can you file a post-conviction motion to vacate a 2008 guilty plea on a 2008 blood case guilty plea where you're trying to then go back and say that they there was no warrant? And the answer in State versus Adkins, at least by the appellate division, was no. There's no suppression of the blood result from a 2008 case based upon the 2013 Missouri versus McNeely case. Case 14. Can an evicted tenant object to items seized from their apartment? And the answer is no. After eviction, the tenant does not have an expectation of privacy. That's State versus Hinton. The landlord let the police in, and that's New Jersey Supreme Court. Case 15. Can the police search an apartment after the landlord calls and said the tenant is not around? In New Jersey Supreme Court case in State versus Vargas said no. The community caretaking doctrine is not justification for the warrantless entry and search of a home in the absence of some form of an objectively reasonable emergency. So let's see what happened here is the landlord was looking for the tenant. The stuff was starting to pile up outside. The landlord let the police in. Probably the police and the landlord did the right thing, but the drugs found in the apartment was suppressed. And that's State versus Vargas. For other information on cases, visit website njlaws.com and website benotguilty.com. That's benotguilty.com. For representation, contact the law office of Kenneth for Cameron and Edison at 732-572-0500. Thank you.